who would have thought the law was going to be so exciting? Who would have thought that code of ethics would lead us to these places, to uncharted territories? If it's anything, I mean, I have personally a lot of questions that I won't start out with. But one of the reasons also for doing this is actively to think from the perspective of the museums that are part of these projects, and not necessarily only the museum in the project, but museums in general, about what might this discussion look like? How might it help us as museums? So if we were to take the conversation around ethics seriously and codes of ethics seriously, what would that look like? And I was reminded by the most recent research done by the American Association of Anthropologists, and they just published a 146-page document on how to treat with human remains in museums' collections. And one part of it I remember in the discussions anyway was around the idea of not foreclosing the possibility of research, but rather what it means for research to be done in the service of community good and community flourishing. So one could also ask the question, what might a code of ethics for exhibition be like for the museum when it is in the service of the community and not in the protection of the museum for any liability or to protect the staff? What I wanted to do is, I have a lot of questions. One of my primary questions will be, going back to my question about good today and the good person and the good mens, is one of the interesting things that I found with many of our presentations, and it is my pet peeve and I know it, is that we could speak so much about law and legality in the first session with very little attention to the subject of law. So to the fact that the legal subject is very often a race subject, a racialized subject. And in that sense, the fact that that legal subject as a race subject has been made an unequal subject for so long, and therefore, do we not need to talk about law, ethics, and racism in one space, rather than thinking about law and, sorry, Wouter, and questions of dignity without even talking about the dignity of whom? That's my question. And my other question was the question of the good person. So questions of who is the subject of the doing act, so the perpetrator, not just on misconduct, but somebody perpetrates something. What might it mean to bring the subject back into that conversation? And I want to tease Quincy, but I won't do that yet. I'll come back to that teasing because I want to tell him that if he's not going to do the research, then I don't know how he's going to do the PhD. But that's a challenge. I want to first open up the question of you all on the platform, because in listening to each other, I'm sure you had questions for the other person that you didn't get to ask. So who has the burning question? Krishna, did you have a burning question for somebody that you just really wanted to ask? Or Wouter, or Marie-Sophie, or Krista? And you really wanted to ask and you haven't asked yet. Do you have that burning question? Anybody? Oh, Suzanne has one. Suzanne, you have a mic?
Yeah, actually, I have a burning question, which is a follow-up question of what Jos asked about the local law, and I was thinking, it made me think we are here in the center of Adat law, which was the codified customary law in Indonesia, which still is very strong within the context of a plural legal system. In the Netherlands, plural legal systems are just out, but in the colonial times they were. And then the remark was made that the codification of the customary law was also done in a colonial context. So then I thought, if we say it was the law at the time, and it was an unjust law, can we then say it was customary law at the time, if already there's such a colonial history in the codification of it? So that was my burning question.
Burning question, and who wants to answer that burn? Anybody? All right, I either call on Marie-Sophie or Wouter, so one of you.
Yeah. Yeah, thank you for that question.
Well,
oh,
yes.
you want to
Start?
Yeah.
Right.
Just to say, you're totally right. And this is something I don't really work on this, but my colleague historian who works on colonial archives, is very much aware that, for instance, the most archives we have, so the most written sources to know exactly how the law was interpreted then, are colonial archives. So you need to take them, of course, with the most critical stance and know that it's one bias on what really happened on the ground. So I think just to say that historians are already much aware when they read the sources they have that you have this colonial setting behind it. But it doesn't really give a perfect answer because, I mean, the question would be, in my opinion, if you can have access to customary law back then, it's already good, actually, to have something. And you have it because it has been codified, but that codification is in itself a colonial enterprise. How can you decolonize it, really? How can you know what's the real law behind it? And yeah, that's difficult. I think that there are oral traditions then that you should have to field research, but we as lawyers, we're totally not trained to do that. So, yeah.
Maybe not the persons who should do it.
What?
And maybe not the persons who should do it.
Yes.
You as lawyers.
No,
Okay.
of course, yeah.
Wouter, a quick response?
Yes, yes, I think it would be very interesting to further look into what Van Vollenhoven exactly did in his compilation and systematization of Adat law and what it implied. And there are some critical studies about it, but not so much. Also one Indonesian one that I know of, but it's still, I think, very much to be done. And to come back on Wayne's remark about race, this customary law was, let's say, systematized as a sort of inferior legal system in a racialized hierarchy of different groups of people within the Dutch Indies. And even this customary law was somehow colonized by this activity of Van Vollenhoven, who, by codifying it, also changed it to his own purposes, with a good intention, so to speak, but it didn't remain the same. So this whole history is very much still to be done, I think, mostly. It shows how much work there is still to be done.
Yes, please.
No, sorry.
I just recalled an interesting example of what happened in South Africa after the new constitution was adopted in 1996, because customary law was then considered one aspect of the multi-layered cake of the Roman Dutch law, the English commercial law, and so on. There was a case concerning primogeniture, which is the principle that only male heirs could inherit land. And the case went to the Constitutional Court after 1996, and the court upheld this principle of formal equality. So it applied the customary law, but without the bias in favor of the male heir. So you can see there that how the Human Rights Bill, the Bill of Rights, which is part of the South African Constitution, shed light or changed, amended in a way,
Right.
the understanding of the codified customary law.
Yeah.
Just an interesting.
Thank you. And Krishma, you had a comment. Do you have a mic? A question. You had a question. Oh, okay.
Yeah, I have a question for Sadia. So you were talking about how in Indonesia there is not really currently, at least in the museum setting, decolonial discourse, and then you're looking at how these objects that come back, how they are presented, and feeling disappointed in that. So I want to ask regarding responsibility, how to navigate that as researchers working for some European institution, because on the one hand, of course, you want to let there be local solutions for these things. On the other hand, of course, as colonizer, there's that you can't also just completely let go of responsibility. So how do you see that?
Yes.
Thanks for your question. Well, how do I see that? So yes, in a way, I'm still an employee of VU until the end of the year. And at the same time, I live and work in Jakarta. So I guess maybe that's how I like to contribute. And I'm trying to learn from what I observe. So on the one hand, my emotion is that I'm disappointed because this is something I've been working on, well, let's say like 20 years. So yeah, I'm disappointed. At the same time, I also think like, well, it's not really fair to others because, yeah, like I said, like there is a lack of criticality in the curriculum. So how can you be critical if you never learned how to be critical? So in that sense, I also realize, I have a privileged position that I am aware of these discourses and what's happening on a global level. So in that sense, I also, I cut them some slack. At the same time, I also think, if I am disappointed in that, then I should do something about it. So I think what I should do is that I want to contribute to creating a discursive space to have these discussions. So, on a small level, I live and work in Jakarta, so I have my own sort of like a company, and we use my social media, for example, as a discursive space to sort of like raise these issues. Like, so that's why we have the social media campaign, for example, about the exhibition, to also share it with, audiences online. And not nobody, but like not many people will be able to travel to NIAS to see the exhibition. So then, why not try to bring it to the people through social media and engage them also in these conversations? And, what can we learn from that? And at the same time, start these discussions, what do these type of collections mean? And not just in NIAS, but I think in Indonesia in general. So I think that's what I'm learning. So I'm actually, to be honest, like I'm really like literally thinking in this time of the year also, like what can I do, for example, in the next 3 years to really reach that sort of like dream of myself to create a discursive space to have these conversations that I think we should be having and are not really happening yet. But it's, it's a step-by-step process. Thanks.
All right, can I have a lot of questions, but I'll hold questions for the audience. Yes, Mike is coming.
Thank you. My question actually is to you, Wayne, for the question you posed to them.
What's that? Which one?
My question is directed to your question.
Okay, whoa.
Because and you rightly point out to the fact that maybe you're talking about race subjects when you're talking about legality and ethics and whatever. So, but if you're talking about race subjects, then shouldn't you be talking about the different positionalities of those subjects doing those acts? That is the first question. And the second question to you is, isn't your rhetoric of Gutmensch wrongly applied to those differently positioned raced subjects? Aren't you yourself running into the trap of being judgmental about those different positionalities of raced subjects?
Yes, the second one to answer.
Yes, thanks.
But I mean, for me, first of all, I didn't want to be on the platform, but it's fine. For me, the question of the race subject, I think, is necessary for this kind of discussion for multiple reasons. One, it takes into account so when Saidia Hartman used afterlives, and I'm interested in how you use afterlives here, She used afterlives to try and understand the calculus of relationality that continues to make some subjects lifeless, deathly, those kind of things, right? So I'm interested in, when we talk about the law, it is just not a bland talking about the law. It talks about how the law, as I said, deal with visa regimes. It talks about the fact that the very same subjects that are racialized subjects in the past are the same racialized subjects that are understood in our migration crisis. It talks about those subjects that are have still not achieved a certain humanity in the waters of the Mediterranean. And therefore, to just speak of the legal needs to account for what that might mean if we are to try and find a solution. That is why I'm insistent on what that might look like. So it is in that relation that I'm interested in us not speaking about. And I think David Scott does that in his Irreparable Evil, and it is very much a dangerous step, because he says one needs to think about the differently positioned Jewish subject in the Holocaust in relationship to black subjects under colonialism. Otherwise, one cannot understand the situation we're in. That some people find him making a comparison. That is not his intention, but he's trying to tease out that subject of irreparability and what it might look like for restitution. And I think that that is something that is important for our discussion. Otherwise, the law feels like it's something out there. I was just in Paris, and as I stepped out of the Quai Branly, I saw so many police trucks, because Quai Branly is close to the Eiffel Tower. There are police trucks there, that's what they explained, there to protect that monument. But I can tell you, when I see police trucks like that, I am terrified in Europe. I am a particular subject to the law. So what does that mean? That's why I asked that question. Is that all right? Okay. Any other question? Peter.
Yeah, and I guess related to this, because one of the it would be first a question to Wouter, actually. One of the things that I was thinking of while you were setting out those actually wonderful steps in your argument is the portrayal of Sarah Savoy as on the side of ethics. But I also think that it's important to look at that subtitle of the report carefully, right? Relational ethics also has the side of the relational to it. And that is something that's been bothering me also, not just in relation to the law, but also in relation to codes of ethics. Right? And this is also about the subjects in multiple senses of the word, the subject of the law and the subject of our ethics. If the aim is to improve something about a situation that we find, among other places, the Wereldmuseum to take part in, then that is a problematic relation to other people, other parts of the world who have a claim to certain artifacts in a collection. And that relation should improve, right? Why would you bother with the law or the ethics if that is not the goal behind it? But then the relation itself is primarily characterized by a social situation of inequality. And I wonder what happens when you would really introduce that into thinking about ethics and law as an ethical and a legal problem, right? If legally speaking, most of us live in society or in nation states that have some kind of constitution that declares people to be equal before the law, but work in practice with all kinds of unequal relationships, is it possible to think of doing things legally and being judgmental about things done illegally by also addressing the problem of inequality itself and the problem of power differences itself. And do we have examples of codes of ethics where acting as if you are the one to be able to tell others that they're not fully equal in relation to you can be somehow declared to be misconduct? It's something that's bothering me for quite a while, and I wonder whether there's an answer to that kind of question.
Yeah.
Yes, well,
Easy question. Thank you, Peter.
yes, thank you for this very easy question. Perhaps, from what I understand, I think Saran Savoy used the word ethics in the subtitle towards a relational ethics, so something like that, interrelational ethics.
Relational
ethics. But I'm not that type of a researcher, but I counted how many times they use words like ethics and ethical in their report and how much time they use the word law. And it's striking that they use the word law and legal much more often than ethical. That's very interesting. So they pretend to be right about ethics, but in fact what they recommend is quite legal. And I think that is interesting because the ethical recommendations can become much stronger if you understand them in a legal way. Because a legal or a right or a legal right is, as for example John Stuart Mill, a legal philosopher, once said, is a sort of crystallized ethics. It is an ethics which you can enforce. So that is what Marie-Sophie tried to say, that you are able to go to a court of law, to a judge even, when you have a right. So there it becomes much stronger. So I think what they try to say, without explicitly saying so, that we need the law to address this problem. Even if they pretend in their subtitle that it's mainly about ethics. But in order to change a relationship that is extremely unequal for a racist past in the colonial times, we should to improve the inequality a bit, but that can only by legal means. If you don't use the law to redress it in a certain way, you don't do anything at all. But even if you do it, and that is, I think, more or less the question of Wayne, even if you restitute objects and at the same time close all the borders and using racist criteria for visa, etc., then what are you doing? That is the question Achille Mbembe also asked when talking about restitution. That is his main problem. So closing the borders of Europe for people and giving back the objects. So what is happening there? Restituting objects and prohibiting people from Africa coming in. So, and that is a synchronicism that happens simultaneously. What does that mean? Also for the restitution credibility. That is a huge problem. But well,
Yeah.
it's...
Suzanne wanted to say something.
I'll leave it here.
Suzanne. No. All right.
Actually, I wanted to make the problem bigger, but also closer to home. And that's in response to Quincy, who says, but the institution where I work and where I gather this knowledge or where I process this knowledge already has an institutional racism in itself.
Mm-hmm.
This is a connection, isn't it?
I mean, yeah. And also, on the one hand, we're restituting ancestors, material culture, collections, we're closing the borders, but we're not closing the borders for resources. Resource extraction is going on. It's intensifying even to a certain point. So I think that there's a connection to be made in terms of seeing the restitution as a means of cleansing Europe once again, or cleansing the past, or cleansing the present from being influenced by that past, right? We're all good now because we're giving it back, while we would not have been who we are if we didn't do that. So it's also this really, and I think Amada just pointed me to this idea of like relations once again. It's all interconnected. Like we would not be here, we would not have this museum to be able to give stuff back if we didn't do that in the first place. So it's all these different things where like, okay, wait. And I think it comes back to something that the writer Sabrine Ingaberi asked me a couple of weeks ago during a event by Sustaining Otherwise by Selina Wind and Amal Al-Haj together with the RCMC. And she's like, but how do you do your work, or how do you get to the point of safety to do your work, right? And I had to kind of disappoint her and tell her, but I mean, from the context where I'm from, it's always been unsafe. The Dutch Caribbean is, on the one hand, supposedly autonomous. It has internal autonomy, but it doesn't. It's a colony by a different name. And so being here and thinking through that, and then thinking about also my shift in research to go from, you know, first all these international contemporary artists into now, okay, let's see Dutch Caribbean contemporary artists, what are they doing with these collections? Then you come to the realization that there are different strategies that people utilize. And so thinking about the SAR Savoy report, I had the privilege and the honor to interview Mati Diop when she was here for IDFA. And one of the things which she told me, and which I read in some of the interviews she did with other people, is that Felwine Sarr actually helped her get access to the Benin government to be able to actually film all of this, right? So on the one hand, he's talking about this law and all this stuff there, but they're doing all this other stuff as well. So it's interconnected. You can't see them loose from each other.
But I mean, I want to move this a little bit by probably just holding on to a few things, because in a certain sense, Peter, your question is massive. The massiveness of that question is that you are also inviting us to imagine an equal world, which I guess that is the project of what all of this is about. That is the project of what decolonization is about. And a lot of what it says, so Sadia, one of the things that if I were to be critical of your presentation, is that your presentation sounds to me that it invites a narrative of developmentalism, that we know how it should be done there, that we from here, which is also a part of the same extractive regime of knowing what should happen somewhere else. So how do we deal with that? And sometimes I think as curators, as in a museum, sometimes the museum will say, and I think that we can solve some problems, but not all of them.
We should always go for all of them.
Okay. All right. Good. Go for all of them. Yeah.
All of them.
All right, good. It is not enough to stop. But I think that there is something about the question of the relational. And that is the relation of ontwikkelingssamenwerking, which is the post-colonial relations that we often have with the same states that we're giving back to. And how do we deal with that? Because that, and actually, Krishma, you also had that when you spoke about ethical imperialism, the kind of 19th century knowing of how the colonial should be. Sadia?
Yeah, I think I understand your point, you know, that maybe you could think in that way that, or maybe you could get to the point where you think that maybe my presentation could lead to this idea of like developmentalism. But that's also like why I said like, it's not fair of me to think that I would be disappointed. Because that's, you know, because I am in that field and I think that way. It doesn't mean that they need to think in the same way. So I fully acknowledge that, but I can also not deny that I did feel that, you know? Yeah. So that's why I struggle, and I do think like we do need a more discursive space in Indonesia, and it doesn't mean that I know or that I have an idea of what that discussion should look like, but there are not enough spaces where we can have that discussion in a critical way.
And that actually goes back to your question, Monica, because I think that the question of the good mensch is not the question of being good, it's the question of knowing that there's a problem that one needs to solve, and one is committed to the solving of the problem. Right, yes. committed to that. All right. Other questions? Come with audience. No, you're all tired? Oh, okay. Ahmad.
Yeah, to go back to your question about the law and race, and I'm really a bit ignorant vis-à-vis the law. I know a little bit of criminal law in the context of forensics. So the thing about race and the law is precisely in the criminal law is that the subject is an individual. And so we are not talking groups, we are not talking clustering. So, and this raises the question with me because of course I see the racism that is produced also through the law. And I wonder whether, well, we have a number of experts here, whether you can just give us a little bit, or perhaps an example how race gets done through the law, while at the same time talking about the individual. How does that happen? How is this paradox there alive in legal practice? This is just curiosity.
Yeah.
Oh, yeah.
There is this example of Namibia and Germany who entered into a joint declaration in light of the Nama Herero genocide in 1904. And where Namibia mimicked Germany's values in that declaration. And so there was a case brought by a lawyer in Namibia, Kauta is his name, to, well, sensitize public awareness that there was a mirroring, and even though there were provisions in the Namibian constitution to make racialism and race contrary to the public policy, all of the executive organs were not doing that. Yeah, so that bilateral agreement is not going forward. And in that relation, there was also a Bible of the Herero or the Nama leader who was restituted from the Lund Museum. So you can see how restoration runs parallel with restitution at times, restitution more in the sense of property exchanges and giving back material possessions.
Anybody else? And then we...
I'm not sure whether I gave the good answer, but the year 1815 was mentioned in, I think, in your presentation, because there was the end of Napoleon, the Waterloo, and then there was a treaty, European, in which restitution agreements were reached about restitution, looted objects by Napoleon's armies. So there's an important year for the history of restitution, you would say. But in the same year, 1815, as I mentioned, in Kandy, there was the exile of the King of Kandy and the massive looting of the palace there by the British, who were on the negotiation table at the same time in Europe, making rules about restitution and also morally making a statement about that you shouldn't do that. But that was a racial idea, because that only applied for the European wars and not for the wars outside Europe. So for me, that is an example of race and law. So at the same time, you are making a very clear statement saying that looted objects should be restituted anyways, legally, looting at the same time, because the looting in Sri Lanka or in Ceylon at the time is against people who are not human enough to be counted in, something like that, because of their race, among other things. So that would be, but I'm not sure whether that is an example that you wanted to hear, but that comes to my mind.
The law, and these are examples thereof. So I was actually really wondering how the law races subjects. So the racing, and in a sense, this is the examples show that, but it's...
Yeah, the Dutch Indies is also a very clear example. The different groups of subjects, which were according to their race, granted rights or lesser rights, especially in the criminal law. The criminal law was different for the inlanders, so-called inlanders, than for the Europeans and the category in between.
All right.
Yeah,
Can I do
Sorry.
Marie-Sophie? And it looks like you want to say something? Yeah, quickly.
No, just to add, certain conventions had colonial clauses. So the European Convention on Human Rights from 1954, 1952, had a colonial clause for some countries that it was not applicable to their colonies. So I think I can think of no better example than that.
And Suzanne, you had something to say?
One of our colleagues at the VU, Thomas Spijkerboer, he connects it to migration law, and his statement is that the Schengen migration laws are racist laws. And so then his argument is, but correct me if I'm too, my language is lay talk, but what he says is, if the effect is that so many people of an other ethnic descent, other race, are not allowed to enter Europe and die, then the law is disproportionate and based on racist considerations.
Yeah. There is a brilliant dissertation that I'll send to you shortly. It was just defended at the Erasmus University. But I think you were asking a slightly different question, and I think there is a whole lot of work in the US, though, where the law, not racist, but it races. And the US is, I think, a lot of the US legal framework races people and turn them into that illegality, which... Yeah. All right, but I think we have to round up now. So, and I want to round up to be very, 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 very selfish. I want to round up with the fact that there is a Dutch policy on restitution, the fact that the museums need help with how are we going to get out of this. So if I were to round up, I want to round up with questions that are, where I might ask Krishma a little bit, what then do I do as a museum if I need to develop a code of ethics that is in the service of for exhibitions, for example, that does not reproduce the same injustices that we've been doing in the past? I want to be a little bit like that for the museum's sake, because this is also about museums and objects. Or how do I not reproduce epistemic violence when I send objects back to Indonesia? Is there a code of conduct or whatever that I could order? So, not to put you on the spot to solve the problems of the museum, but you're on the spot.
I indeed cannot solve the problems, but I do have an answer that might be somewhat helpful. Not content-wise, but just process-wise. I think who is included in the drafting of that document is key here. So including the people that it will affect, and including people that understand the problem, are not ignorant of it, and are really willing and committed to not reproducing these colonial dynamics. I think that's key.
All right. I think I saw Krista lift her mic. You wanted to say something?
No, I think that was in connection with the racing of people. I just had an example, but it's no longer so pertinent.
All right. Sadia?
Yeah, may I add to that? Because I fully agree with you, and thank you for raising that. Yeah, I agree, involving, those voices of people who would be affected by the code of conduct, who the code of conduct is trying to protect or be respectful towards. I think they should be involved. I think maybe also, people working in the field, etc., should be involved. If, for example, like repatriation, I think the one thing that we learned, at least, or what I learned from this whole process and being involved in this repatriation process in Indonesia, is that we didn't really think it through beforehand. We just acted like very proactively and very, very pragmatic, but building on historical discussions. But now is also really the time to reflect on that. And I think a code of conduct, I would see that also as a work in progress. It's not something static. It's something that you need to sort of like from time to time revise, because you learn every single day. And for example, like the work that I've done in NIAS, or trying to do in NIAS, you know, I've learned so much from that, like how to work with source communities and who are these people in the first place. And they also amongst themselves ask, are we, you know, the right people to work with you, or are there others that need to be involved? So all of these things, I think we should be like really aware of that and sort of like try to let that feed into, if you want to write a code of conduct, to sort of like set up a best practice type of situation. But yeah, I would say like just involve as many voices and experiences as possible and just take it from there.
Right. Any other last burning question from the audience, comment? Yes, Quincy? Yeah.
And I think that's for you, Marie-Sophie. You mentioned the case of the Italian sculpture and the Getty versus Italy. One of the questions that me and Stacey Mee were discussing, would the outcome have been different if it was an American court instead of the European Court for Human Rights?
That's an interesting question. So there is an Inter-American Court of Human Rights that exists, and I don't know it would have been different, but what I do know is that the American court is much more interested also in collective rights, in rights of indigenous people, also because of its history, of course, in Latin America mostly, or everywhere actually, in the US, of course. But there are a lot of cases in Latin America. It's also very interested into cases, cultural rights in the broad sense. I have a case in mind, look at, of a local community, also environmental rights. So it's much more open to these collective rights than the European Court of Human Rights. And actually it's true, they could have gone to the Inter-American Court of Human Rights, but I think they went to the European Court probably because it was also against Italy, but maybe because the European Court has much more an individual rights system, civil rights, individual liberties, individual property right, which is different. And I think the strategy was also to make sure, guarantee their own property right, and it backfired somehow. I don't know if that answers a bit. Yeah.
All right. Thank you all. You can stay or you can go back, because we're just going to close off right now with our last few minutes of saying. This has been a joyous morning, afternoon as well, just thinking through these possibilities. And it's always interesting to be able to speak about these things. I am minded by what Krista said, that perhaps if we were in another place, it might not have been so easy to talk about some of these topics. So it was good to be able to speak them uncensored. We were supposed to talk about the legal or the ethical, and I think that if Wouter would have opened up with us thinking the importance of the legal and not hiding from the legal, we probably would have ended the day to suggest that we cannot think them as separate. We can't think one or the other, to pit them as separate, but that they are sometimes conjoined, but that we have to take them together in terms of what we want to do as institutions for pushing things forward. I started this morning with my who would have thought, and it is also just simply because a framework on Dutch colonial objects framed in the ethical, for me, has done work that I could not have imagined to have done. So the question today was never to just simply criticize that framework, but to ask, what might it mean to push it forward? 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 What might it what might it mean for it to become legal? Does making it legal also push against the possibility that it will be shoved under the carpet when a new government comes into framing? What might that mean? But today still leaves me confused. It's a conversation that leaves me wanting. I think it was Birgit talking in the corner when Birgit says, we leave today with more questions than answers, which is always the case with this topic and with this project. And notwithstanding, we've come really far. I am still concerned that most of our disciplines are disciplined without subjects. I'm still concerned. I'm still concerned that many museum studies and heritage studies and even anthropology students discuss these questions without discussing the subject around which that happens. So I'm writing a book now with Kiara, who couldn't be here, asking the question, what does museum heritage and memory studies look like when race and racism is a part of the analytical histories that you trace when tracing those disciplines? But we leave today, I think we have to leave today thanking the presenters. I was especially enamored by a few things which I'd like to mention before we go. Reclaiming the sacred. There was a conference we did, a biennial conference we did on questions of ancestrality. And I was enchanted by that reclaiming of the sacred to perhaps do something that Krista wanted, but something that some of you have been asking for in work package. Which one are you in again? 3B. That work package 3B has been trying to ask that question. But it has also been asking that question, I think, because it is contending with the fact that perhaps some of the disciplines that we are a part of today have emerged in a moment when there was a splitting between the sacred and the secular, between the objective and the other side. And so you've been trying to do that, to suture that wound of the past so that we can think about what might it look like differently if the sacred were to come back into our conversation. And how would the government's committee operate differently if they were to take that more seriously? And we've discussed work package 2A and 2B a lot today around provenance research, ownership or provenance, origins or provenance, but also around the very notion of the law with Wouter, but also with Stacey Marie, who has been interested in asking that question as well around the sacred. So today has been good for us. We are now at the end, not only of the day, but almost at the end of this project. I say with nostalgia. And it is not an end in itself, because in February, I think it is, or March, where's Lars? Lars? March 15. Okay. In March 15, we are going to have that experimental exhibition that is going to open in Groningen Museum that looks again at what do we do with these historical figures that we've always regarded, Monica, as good. And now we are bringing criticality to their work in the present. And between April 17 and May 12, I will give you a broad space, because April 17, the exhibition, the big exhibition on pressing matter, will be ready at the World Museum in Amsterdam. And it will probably open in May, giving some time, where that will actually contend with the ideas that we've been grappling with. What does ownership look like? What does value look like? What is provenance? What does it look like to think through the question of potentialities? And we've described it as Restitution 101. It will be a simple exhibition to just give people, when people just say, but it was legal at the time, it will help answer that question. Mwah, we're not so sure. And it will continue because in October, another exhibition will open at Framer Framed, which will take up contemporary artists' relationship to this theme. And during that period, a lot of our PhD students would have graduated. Yay! We hope. Or almost be finished. You know, there's some time. Almost be finished. And some of our postdocs have already left, unfortunately. But they will continue because we are putting together a book project that brings all of the project together. And hopefully that will be available not only as academics responding to the question, but a second part of the book will be code of conducts, guidelines, help for museums in how we do it better. Thanks to everybody. Thanks particularly to Suzanne and Karina for brainstorming and making this possible. And thanks to everybody who participated. And thank you, Saidia, for coming from so far to be here. But thanks to you all for being here. And let us continue talking later on downstairs for a drink and later on in the coming year as we bring the project to a close. Thank you.